Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. And we're going to circle back now on magazine bans, and in particular, the case of Duncan v. Bona. Yes, that is that Duncan v. Bona, the case that every time we talk about it, it makes your blood boil. Well, as we know, the Ninth Circuit, full en banc panel, has now taken review of it, and we know what in all likelihood is going to occur, but there is at least a piece of good news or bad news. I guess it depends on if you're a glass half full or a glass half empty kind of person, but I think we do need to disclose to you who is actually sticking up for your rights and who doesn't. So today, let's spend a few minutes and talk about how half the states are willing to fight for your Second Amendment rights. Okay, so the case we're talking about is Duncan v. Bona. It is a challenge to California's high-capacity magazine ban. It has been going on since literally the beginning of time. We're not going to go through a total instant replay of everything that has happened, but essentially, if you could just take a look at anyone get kneed in the groin on two separate occasions, you would understand what has happened to the plaintiffs in Duncan v. Bona. After the plaintiffs prevailed yet again after a full trial on the record before the Honorable Roger T. Benitez. This time, the second go-around, the Ninth Circuit decided they'll just suck it up like a big old Hoover vacuum cleaner and hang on to it, and God only knows what's going to happen to it. But as we all know, the full Ninth Circuit en banc panel would not be so eagerly accepting a case unless their intent was to actually overturn Judge Benitez's ruling or translate uphold California's magazine ban. Now, we are at that time of the litigation season when all of the amicus briefs, friends of the court, those who are supporting the plaintiffs or those who are supporting the defendants, all need to start filing their briefs. And we've already talked about this rather troubling brief that came from a multitude of attorney generals around the United States, many of which were actually in states that did not have high-capacity magazine bans yet. Well, what I'm going to share with you today is, and again, if you're a glass half full or a glass half empty kind of person, I guess you're going to have to take it the way you need to take it. But there has been an amicus brief, a very well-drafted, very concise amicus brief filed on behalf of the plaintiff, Miss Duncan, that is in support of Judge Roger T. Benitez's ruling, which found that these magazine bans are unconstitutional by 25 separate attorneys general from various states. We'll give you the list in just a moment, which means, yes, half of the states of the United States are willing to fight like hell for your otherwise inalienable rights. That's one way of looking at it. The other way of looking at it, of course, is the other half are not willing to do that. Now, this entire amicus effort was spearheaded by Montana Attorney General Austin Knudsen, who is rapidly becoming my favorite Attorney General anywhere in the United States. Mr. Knudsen, if you ever want to come on the channel, give us a call. Okay. And then it is co-authored by Attorney General Raul Labrador of the great state of Idaho. So those are the two main authors. So you have Montana and Idaho essentially spearheading this amicus efforts. However, many other attorneys generals have signed off on it, and they include the following: Alabama, Alaska, Arkansas, Florida, Georgia, Indiana, Iowa, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Texas, Virginia, West Virginia, and Wyoming. Okay, I'm just going to give you a few highlights so you can understand it. We'll link the whole memorandum up down below so you can geek out on it for yourself, but give you just some highlights of where all of these attorney generals are coming from. They're essentially making three arguments. The arguments that they make very succinctly are: 1, magazines are arms protected by the Second Amendment. 2, California bans magazines typically possessed by law-abiding citizens for lawful purposes. And 3, the magazine capacity limitation doesn't align with this nation's tradition of firearms regulation. Now, if you do geek out on the memorandum, you'll see that the state is routinely responding to a brief by the state of Massachusetts, which spearheaded, of course, the efforts on behalf of the state of California's position, which is, hey, there's nothing wrong with this at all. The attorneys generals to this particular memorandum start off as follows. Last year, the Supreme Court had enough of the lower court's disregard for the Second Amendment. It decisively commanded that courts must no longer interest balance a fundamental right and must look to the Second Amendment's text, history, and tradition to assess modern firearm regulations. In fact, the Supreme Court 3 times now has warned courts not to treat the Second Amendment as a disfavored right. Now, one of the first positions that the Attorney Generals offer here is hey, this ridiculous argument that magazines are not protected by the Second Amendment because they don't constitute arms, which is exactly the position that the state of California and the state of Massachusetts is taking on that. It's ludicrous. And one of the things that attorneys point out in favor of the plaintiffs is this. The right to possess firearms for protection implies a corresponding right to acquire and maintain proficiency in their use. The core right wouldn't mean much without the training and practice that make it effective. So here's the real creative way that the attorney generals try to kind of dissect this argument here. And it's the car example. For example, if we decided that we couldn't really ban gas burning cars, but instead we just banned any car with a gas tank, well, you can see that the car would have very, very limited function, albeit it could be used in a very limited purpose, but certainly not to the desire of any end user. Now, take that same example with firearms. We can't ban firearms, but we can ban magazines. And what that literally leaves the user with is a single shot firearm, regardless of what its intended platform is. As the plaintiffs put it, Massachusetts characterizes magazines as storage containers for bullets. That's true in the same sense that a motor vehicle's gas tank is a storage container for fuel. It's theoretically possible to operate a gas-powered vehicle without a gas tank, but that would severely limit its function and utility. Now, perhaps the most offensive argument that any of these states are making is that magazines don't constitute arms, they instead constitute accoutrements. Now, accoutrement is a fancy word for some extra flair that you wear in dress outfits when you're doing something of a ceremonial nature. The thing about it is that the exercise of what is a constitutionally guaranteed inalienable right is really, there's nothing ceremonial about it at all. That should be called one's daily life. Furthermore, if you could ban anything that you label as an accoutrement, what stops you at magazines? Why not the triggers? Why not the optics? Why not anything else that actually makes the firearm usable? Okay, so then the next thing the attorney generals move on to, of course, is the common use test, because that is what this whole case is about. As they point out, Bruin next directs courts to determine whether magazines with greater than 10-round capacity are typically possessed by law-abiding citizens for lawful purposes. The answer is unequivocally yes, so they cannot be considered dangerous and unusual. And that is the critical test under the common use test. Let us remember that the only historical tradition that this country has is banning certain types of firearms, or only those platforms or types of weapons which have been deemed dangerous and unusual. And when we start talking about the most common type of magazines in circulation today by millions of lawful and responsible gun users, there's absolutely nothing unusual about any of them. Now, the other thing that the attorney generals had to respond to, and I find this to be perhaps one of the most disgusting arguments by the civilian disarmament regime, is the whole, well, you know what, you don't need any more than 2.3 rounds. You see, because our data says that in an average self-defense situation, only 2.3 rounds are fired, which of course, if we accept that logic, means you will have states inevitably start reducing magazine capacity to 3 rounds. Let me explain to you how the attorney generals first dealt with it. Actual firing of a handgun is irrelevant. Instead, the constitutional protection is afforded to weapons typically possessed by law-abiding citizens for lawful purposes, focusing on typicality and possession rather than the frequency of firing. Let me try to explain the entire fallacy of this 2.3 argument. First of all, the data is quite shaky, but let's just assume in arguendo that an individual typically will only discharge their weapon 2.3 times in an average self-defense situation. Let's make everything average. Let's take also the most common firearm carried probably by most Americans, the Glock 19. Now, if you are in a self-defense situation and you are in a position where, in fact, you discharge the firearm 2, maybe 3 times in self-defense, that may be sufficient and you may be lucky because you are now the statistical norm. But even though you have only discharged this firearm 2 or 3 times, you have still utilized and used a 15-round magazine. There's just 13 or 12 rounds still left in it. And then, of course, the coup de grace of disingenuous arguments as offered by the state of Massachusetts and several other states, including mine, is that, well, there is a historical tradition of limiting magazine capacity. I mean, after all, we did limit how people could store gunpowder. Now, I really like the way the Attorney General's decided to respond to that as follows. In other words, Massachusetts would have this court evaluate the modern regulation of apples by analogizing to the historical regulation of oranges. In some cases, that could be appropriate, but we have a better historical analog, the actual regulation of apples or lack thereof. So the case once again is Duncan v. Bona. You are all familiar with it. There is no case that has a more sordid or terrible history than this case. We will link this brief up down below so you can geek out on it for yourself. In the meantime, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to be able to get a hold of Washington gun law. If you don't, that information is down there in the description box also. Now, in the meantime, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.